Hello, everyone. As we start our discussion of Chapter 3, the overall learning objectives for us in this chapter, first I want us to be able to understand the two different court systems that have been established in the United States under our constitutional system of government. So, as many of you probably already know, we have a federal system of government. So, what that means is that there is a national layer of government that has national powers. So, things that Congress and the president enact into legislation would be binding on the entire country. And then every state has its own state constitution and state government. And so they're allowed to have certain powers within their geographic territory that we call states. So, in terms of the court systems that we have created in the United States, essentially there's two systems overall, just like the broad big picture. There's federal courts, and obviously those exist across the United States in what are called different circuits. Then every state has its own state court system, and I'll kind of go through the basic structure for each of those systems. I want us to understand the concept of jurisdiction and how that has implications for, like, what types of courts can hear cases, as well as specialty courts, which we'll get into some examples of each of those. I'll briefly talk about different stages of civil litigation. I don't get into criminal litigation in this chapter, but we'll discuss, obviously, civil litigation. So cases that involve anything non-criminal. So it could be a contract dispute, it could be marital dissolution, it could be child custody, it could just be any other type of, again, non-criminal civil suit that parties may have against each other. Then near the end of the chapter, I distinguish some alternative forms of going to a traditional courtroom, and so these are usually called alternative dispute resolution, or ADR. And there's many examples of ADR that exist. There's two that I primarily focus on, and that's mediation and arbitration. So that's big picture, what we're going to be looking at in Chapter 3 today. So when we look at the court system, whether you're looking at the state system or the federal system, they both do kind of mirror each other in essential structure. So I think of the court system in my mind. I conceptualize it as a pyramid. And so if you can imagine a pyramid, at the very base of the pyramid is where it's widest, and then as you go up to the top of the pyramid is where it gets the most narrow, and ultimately where you reach like just one specific point at the top. And so kind of thinking of a pyramid structure when you conceptualize our court systems. So we have three layers of courts or judicial kind of process. And this exists this way in both the state and the federal system. So at the very bottom or entry point into the court system, you would have our trial courts, and that's usually the entry point for almost every case. So again, if it's a civil case, and let's say have you been injured, those types of cases. So you identify a potential defendant who you think harmed you. You would serve them paperwork, and then they would have to appear ultimately in front of a judge in a trial court. After that, at the end of a trial, somebody wins, somebody loses. So that's true, in both civil and criminal cases. And in the civil case example, let's say that you lose, but you think you should have won. So you have another step, or like the next level you can kind of level up to, if you want to think of it like that, which would be an appeals court. The entire purpose of an appeals court, and then ultimately at the top of the pyramid, which would be a Supreme Court, the entire purpose of an appeals and a Supreme Court is to review what is called the record below, or the judicial proceedings, and to make a determination if there were any mistakes that were made. The judicial process is filled with human beings, judges and the attorneys involved, the parties, juries, all that stuff. And so there always is the potential for mistakes to occur. And so, the appeals court as well as the Supreme Court, that is their job to identify if mistakes were made. If there were no mistakes, then they just affirm the decision below, which means, they kind of rubber stamp that it was decided correctly. But if there was a mistake, they will make some kind of recommendation. They could reverse the case. They could send it back down for reconsideration. There's a lot of different tools at their disposal. And this is all part of a greater picture, which we'll talk about in future chapters involving like due process rights. We want to make sure in the United States that everyone is treated fairly, but at the end of the day, justice will prevail and the right party will win. That's aspirational. You can debate whether or not that actually does happen in specific cases, but that's a different issue, different discussion for a different day. Anyway, so yeah, that pyramid, if you kind of going back to that shape again, so at the very base of the pyramid, I think of those are our trial courts, because that's the most common type of court that exists in the U.S., both state and federal. There's lots of judges that will man those different judicial positions at the initial entry point in the judicial system. As you go up the pyramid, near the center part of the pyramid, that would be the appeals courts. And so, again, there's less cases that get appealed. At the end of the day, for the trial court, just to kind of go back to that bottom layer, whoever loses, most of the time, most parties are like, well, I had my day in court. And so even though I lost, which is not fun, or I don't like it, you don't really want to expend more energy, more resources, more money, more time further litigating or trying to relitigate the case. So it's just over. But if you really do feel compelled that there was mistakes that were being made, or you really do feel that maybe some of your core fundamental rights are being infringed upon still, then you would have the basis to appeal your case. And so the appeals court, the middle layer, as you're going up the pyramid, again, they have to decide at trial, did everything happen correctly or not? And again, at the end of the appeals court process, somebody wins, somebody loses. And so the party that lost at the appeals court level, if they feel they should not have lost, then you have one more shot by going to the Supreme Court. Every state has a state Supreme Court in the state system. And then obviously in the federal system in Washington, D.C., we have the U.S. Supreme Court. So that gives you kind of just a basic kind of feel for the lay of the land, so to speak, when it comes to the different types of levels within the court system. So this slide gives you a little bit more detail, and again, I won't read all this, but it's a great reference. So as you're trying to again kind of process, well, okay, what does what are the different options? What are the different procedures as you're maneuvering, throughout the entire court system in state versus federal? One interesting thing to note is that if you're going through the state system, so let's say, for example, crime, which we haven't gotten to yet, most crime that occurs in the United States is state-based crime. So if there's assault and battery, if there's burglary, if there's robbery, if there's one of the different many forms of homicide that occur, usually most of those cases are state-based violations. And so, the state systems get a lion's share of the cases, criminal and civil. And so, let's say, you're a criminal defendant and, you lose at trial, you lose on appeal, you lose at the state Supreme Court. The state system does give you one additional option for process from a judicial perspective, and that's the U.S. Supreme Court, which is in the federal system. So it's kind of a weird kind of leap that you could make potentially from the state system into the federal system. You're not going through a federal trial court or federal appeals court. You're appealing your case from the state Supreme Court all the way to the U.S. Supreme Court. So you're kind of bouncing out of the state system and you're trying to, land in the federal system. I don't get into a lot of the details. It's a fascinating process in trying to understand what types of cases the U.S. Supreme Court decides to hear. They get to decide the cases that they want to hear. There's no mandatory, oh, you have to definitely hear this case. Even though if it does have significant importance, from a judicial perspective or maybe just, societal influences, there may be a lot of pressure to put on the court to hear a case. But at the end of the day, they have a lot of discretion when it comes to what types of cases they want to hear. Every year, the U.S. Supreme Court in Washington, D.C., The typical average number of appeals, they're called writs of certiorari, and they usually get 7,000 to 8,000 of those approximately every year. And the court, if you are an enthusiast or fan of the Supreme Court, you know that they only hear about 70 to 80 cases a year. So that's about 1% of all the cases that that they could potentially hear, they actually do hear. So it has to be of critical importance, some significance, and so. But again, that gives you hopefully a better understanding of kind of like what's going on in the state versus the federal system. If you're going, like let's say you start in the federal court system, and so you start at the federal trial court. Normally, then what you're dealing with is maybe it's exclusively a federal issue. So we're talking about jurisdiction now. Maybe a federal law applies, not necessarily a state law. And so that's why a case might start in the federal system as compared to the state system. And to give you an example of a case that would it be exclusively a federal case, you think of kidnapping. Kidnapping is something that automatically triggers federal law. And so, if you take someone, and you're holding them against their will, especially if you cross state lines, that's going to be litigated as a criminal case, assuming they capture the suspect and they build a case and have sufficient evidence. Then that would go through the federal court system, not the state system. So, but again, everything is driven by who has the authority to hear a case. Is it a particular state court, or is it the federal court system? And that's something that is usually dependent upon both the facts involved of the case as well as the law that allegedly is at issue in terms of what's maybe been violated or not. This is an example of the federal circuits that exist across the United States. And so in every state across the U.S., there's at least one federal court. And then within every region, and you can see there's different colors for different regions, every region has a centralized location for their court of appeals. So when you look at Florida, for example, we're in the 11th Circuit, and so if any of you have traveled, here in downtown Orlando, you know that right along I-4 there's a federal courthouse, and so that's one of several courthouses that exist across the state. And so, if there is a federal trial that occurs, let's say it's at the federal courthouse in Orlando, so that's where the trial is. And let's say it's a criminal case, and the person is convicted. And so, again, they feel like maybe they should not have been convicted, and so they want to appeal their case. Well, as you look at the map for every region, you'll see that one of the cities, that next to a city name, you might see a star near it. And that indicates that's where the Court of Appeals is located for that circuit. And so if you want to appeal your federal trial court conviction that happened in Orlando, then your attorneys would have to go to Atlanta, Georgia. And then that's where you would actually litigate for the Court of Appeals within the federal system. If you're out west, and let's say you're in the 9th Circuit, because that's a huge territory for the United States. Let's say you were in Idaho. And so, you get convicted for some kind of federal crime at the federal courthouse in Boise, Idaho. And again, you want to appeal it. You would appeal it to the appeals court, which is located in San Francisco. After the appeals court, again, whoever loses, if they want to try and further appeal it to the federal U.S. Supreme Court, we know that's in Washington, D.C. And we also know from what we discussed on the previous slide that, that's only if the U.S. Supreme Court decides they want to hear your particular case. Sometimes students ask what the criteria is for the U.S. Supreme Court when they're deciding. They actually have what is called a system called the Rule of Four. I don't ask this on a test because this is more of a political science type question. But the justices will regularly meet throughout their year, so to speak. The year for them starts the first Monday in October, and their session usually will end late June, early July, the following year. And then they have about 2 months off for like just a break. And but anyway, so throughout those months that they are actively in session, they will regularly hold meetings, and it's all kept in confidence. And they'll review different writ of certs that have been, formally submitted to the court for the court to consider their case. And if 4 of the 9 justices want to hear the case, then they hear it. If it's 3 or less, then they pass. And so that's just the rule that they've come up with. It's not a rule that's in the Constitution. It's just a rule that they have that's how they've, kind of decided as an independent institution of government. They're one of the 3 main branches. That's how they decide if they're going to hear a case or not. They can't hear all the cases because there's only 9 people on the Supreme Court. And, even if they were to try and hear 1,000 cases, they could not do it. It's impossible. So they have to have some kind of filtering mechanism to, hear the really important stuff. And then if it's not as important, or if they think it was decided correctly, then they just say that they're going to pass on a case. So I've been mentioning jurisdiction, and so, there's different elements or different ways in which you can kind of conceptualize what jurisdiction means. So obviously, when we talk about subject matter jurisdiction, that covers types of proceedings that a court may hear. There's limited jurisdiction. Sometimes those are referred to as specialty courts. In the state system, for example, we have a separate system of courts and judicial system called the juvenile system. Every state has that. There is no federal juvenile law, but on a state-by-state basis, every state has juvenile law. And so these are cases that involve persons that are under the age of 18. I always mention this because I'm just have an interest in this area. If you ever hear or know of someone who has gone through the juvenile system in any particular state, roughly half of the cases on average involve, matters where teenagers made bad decisions. They're young, they made mistakes, and so the juvenile system, we try and devote as much as we can in terms of resources to figure out, well, why did you do this whatever this bad act was, and can we, somehow get you back on a better pathway in life. And the juvenile system, it's a tremendous mission that they try and have in order to carry out that goal. The other groups of cases that the juvenile system deals with, and this is what can be heartbreaking, is when children, or again, anyone under the age of 18, if they're in an environment at home where they're being abused in some way, so physically, emotionally, psychologically, sexually. And so the juvenile system, they absorb those cases also into the juvenile system, and the goal is to try and get them placed in a safe environment. Hopefully with, maybe another family or someone that's close to the family, so that it's not to minimize the damage on the young person involved. But yeah, so I always say that, if you ever hear of someone and they mention that they were going through the juvenile system, please don't instantly think, well, what did you do wrong? A lot of cases, tragically, are just because kids are in just bad environments that they have no control over. It's the adults that are kind of putting them in this bad situation. The appellate jurisdiction, obviously, by the very label appellate, that means that, that those are those upper levels of the courts in both the federal and the state system. And their singular purpose is to decide, did the lower court make the right call? I'm sure many, if not all of you, have seen courtroom dramas, on TV shows or movies. And we have an adversarial system, civil and criminal. So you have, 2 sides that are pitted against each other, and the judge is like the moderator. The judge maintains control and decorum in the courtroom, and they provide assistance in guiding cases from initial filing to their conclusion after a jury renders a verdict, if it's a jury trial. Anyway, we probably have all seen examples where attorneys will jump up in a case and say, I object. And then usually the judge, he or she, their response is, they might ask for clarification. Why are you objecting? And they'll either say sustained, which means, okay, I agree with you, or they'll say overruled, and that means I disagree, please sit down. And, those objections, when objections occur, it's not a surprise to anybody in the room. It might be to the jury, but they're just sitting there listening. They don't really know what's happening as it unfolds. They're just listening and observing. But each side knows what the other side might want to object to. It could be maybe the introduction of new evidence. It could be a last-minute witness you want to add to the witness list. Whatever it might be. You certainly are going to make your objections with the judge, maybe in private chambers, but then obviously in open court, you have to officially kind of lodge, your objection. And then, again, judges will either say sustained or overruled. So fast forward, let's say that, you made 50 objections in the course of a trial, and let's say 40 of them were overruled, and only 10 were sustained, and you end up losing your case. So you could say, well, I'm going to appeal, and the basis for the appeal, it's not because you lost. Obviously, that's why you're appealing, but you can't say that as your reasoning in the appellate paperwork. You have to say, well, for these 40 objections that I made that were all overruled, had the judge, kind of sustained any one of those, it would have been a different result in the case. That's at least what you're going to try and argue, at the appellate court. And again, that's the purpose of the appeals court. They have to evaluate all those, decisions, major and minor, in a court case, to make a determination. Did the party that lost, did they at least have a fair chance? And if not, how can we, kind of right that wrong if there was a mistake that occurred? Some terminology, if you ever see the word plaintiff, whether it's in the textbook or you just read it, in any kind of, article, newspaper, online, wherever, plaintiff instantly means civil case, so non-criminal, and plaintiff is the party that brings the case. If you see prosecutor, instantly think that's, a criminal case, not civil, and it's the government that brings criminal cases. So, I always try and give examples, and I always pick on myself. Let's say that, after class, I get robbed. And so someone with the threat of force, they approach me in my presence, and, maybe they point a gun or a knife at me, and they want my money, they want whatever I have on me of value. And so I'm like, okay, fine, take it all. It doesn't matter, I can replace this stuff. And they leave. Hopefully I don't get killed or hurt. And so, I contact the police and I report that a robbery has occurred. So, they come up, they show up, they do their thing. They try and collect evidence. They take a statement. They try and find the person, hopefully that allegedly did this, that committed this robbery. And so, let's say they find the suspect. And so they've arrested this person. It's the prosecution's job to decide whether to charge, how to charge, who to charge. And it's not up to me. I mean, certainly as the victim, they'll listen to me. If I'm very emphatic that I want this person to be prosecuted, that's going to put pressure on them that they're going to want to see this through. If I'm very non-cooperative and I'm like, look, I don't want to be involved in this. It was terrible what happened, but I don't want to go to court and relive this and see this person again. I mean, I could be like that. And so, if that were the case, then, the prosecution might be, well, if you're the key witness and you're not even willing to kind of, comply and show up to testify, unless we compel you to show up, they may not be interested in seeking the charges, or they may just say, let's try and do some kind of generous plea arrangement. So prosecutors, they're the ones that kind of own criminal cases. They're the ones that are in command of, like, again, who to charge, how to charge, or whether to charge. The defendant is a collective label. You could be a defendant in a civil case. You could be a defendant in a criminal case. So that label has, dual applicability. Whenever you see privilege in the context of anything legal related, privilege is an area of the law that protects special forms of communications between or among parties. And the idea is that some conversations and some, relationships are so kind of special that we're going to protect the nature of that relationship and whatever conversation that was made, between or among those parties. So attorney-client is one example of that. If let's say I never practiced criminal law, but let's say I did, hypothetically. If I had a client come in and say, look, I want to hire you as my attorney, and, I'll be like, well, okay, did you commit a crime? What's going on? And, let's say this person confessed to a murder that has been unsolved for years. And so maybe they never found the body, hypothetically. And so they tell me this is where I killed the person, this is where I disposed and how I disposed of the body. I am not allowed to share that information with anybody because, that is the attorney-client privilege. It's the client that maintains that privilege. And the only way I could ever speak about that is if the client basically said it was okay for me to do that. They would release me from my obligation of secrecy. That flows to my staff as well. So paralegals or legal secretaries or assistants that might come across documents dealing with this client, they're also bound and they're not allowed to speak about the matters of this case. Change the facts a little bit. This is where the privilege does have limits. If that same client says, well, I'm a serial killer and, I'm planning on killing somebody, this weekend, the privilege does not protect a client for future criminal activity. It only protects their communications about past criminal conduct. The reason why the privilege exists is that we want to afford clients the ability and security in knowing that what they say is not going to be, revealed without their permission, and it will help the attorney hopefully, represent the client should they get arrested and charged. Other types of professions that have privilege, there's doctor-patient privilege, there's like psychologist, psychiatrist patient privilege. I've heard it called different things, but I've usually, like when I was in law school, it was like priest penitent privilege. But that applies to anybody that is, in a particular religion who is a leader within that religion. So it could be a pastor, a minister, a rabbi, a cleric, priest. And so, if you go into confession or if you have some sort of, again, private conversation, that's usually a key thing also. It has to be in an environment of privacy where no one else can overhear. Then again, that's protected communication. And whoever you tell that to, they can't share that with others unless you give them permission. Anyway, statute of limitations, I'll just mention that real quick at the very end. There's this concept under the law that, there's a kind of like a time restriction when it comes to seeking whatever the relief is you're looking for. So if it's a civil or criminal matter, you have a window in which, you can bring your case, whether you're the plaintiff or the prosecution. And then after that window closes, then even if evidence or something else new comes up, the case would just get dismissed. You could not be allowed to bring it. The only exception under the statute of limitations would be for murder. And every few years you'll hear of a random case where someone committed murder 50 years ago, and then the police finally figured out, like maybe through some sort of DNA evidence or new someone came forward, I don't know, and they were able to find the person if they're still alive and charge them and convict them for if it's one of the forms of homicide. But other than that, most statute of limitations, especially if you're talking about civil cases, can be anywhere from like 2 to 4 years. And that's usually dictated by statute, whether it's federal or state statute. Stages in a civil lawsuit. So there's pretrial stages, and then there are trial stages. And so again, I won't read all this to you, but you can see at the pretrial level, initially you file a complaint, and that gets served on the plaintiff, by the plaintiff on the defendant. Trial stages, if you go through all the pre-trial motions and there's no settlement and it looks like you're going to have to prepare for trial, then you see all the different stages that exist in the actual civil lawsuit process. And so usually you begin with what's called voir dire, that's jury selection. Voir dire is interesting. If any of you have ever served on a jury, Florida, the rule in Florida, and a lot of states are like this, is that if you have a valid issued driver's license or state ID card, then you're potentially in the pool on a county by county basis to have that name randomly pulled, whenever they need a potential jury pool. And usually what happens is you're given a notification, usually through the mail, and so they'll mail it to your physical mailing address of record, and they'll indicate, in that correspondence, you need to show up at this courthouse, this day, this time. And it's always within the county where you live. So if you're here in Orange County, in let's say Orlando, you're not going to get a juror summons to go to Jacksonville or to Cocoa, because those are completely different counties and cities. So it will only be within Orange County. And, you show up, and normally, let's say they need 12 jurors for a case, they might send out 50 notifications, because they know as people show up, there's going to be people that are going to be excused for whatever reason. And so, it could be an economic hardship. Maybe they're a caretaker for an elderly person or a family member. Maybe it's a single parent, and they just they just can't do this without some significant hardship in some way. They might just not be suited. I remember, if you remember years ago when the Casey Anthony trial happened, they had to go over to, I think, Pinellas County, which is, I think, west of Tampa, St. Pete area, for their jury pool. And they televised the voir dire. Now, you couldn't see the actual individuals, the potential jurors, because there's privacy, expectations, but you could hear their answers. And I remember, seeing this on television, where the attorneys involved will ask questions. And usually, when you're being considered for a juror position, first thing they're going to ask is, what's your name? What do you do for a living? Do you know anybody in this courtroom? They're trying to figure out, can you be unbiased and can you just hear facts and information and testimony and make a decision? They want you to be as fair as possible. And I remember this one gentleman, one of the questions they asked him after the preliminary questions, they said, have you heard about this case? And it was a very high-profile case for those of you that can remember back then, especially if you were living here in Central Florida. And he had said, yeah, I've heard about the case. And that isn't necessarily a problem. I mean, especially for these notorious cases, it's hard not to hear about them. And the attorney followed up. They said, well, what do you think? And the guy was very respectful. He said, I think she did it. And then I knew what the attorney was going to say before he even said it. And he said, thank you for showing up for your time today. You're excused. We don't want people that have already made their mind up about a case, because, we want you to be open-minded, objective, unbiased, and just listen to the facts that are presented to you in court. And then at the end of the case, after you have closing arguments, the jury deliberates, they look at the evidence, they, consider the testimony, and then they vote. And, they vote for, the plaintiff or the defense, the prosecution, the defense, whatever the type of case is. But fascinating process. And, a lot of times in my travels, I hear people kind of groan when they realize they have a juror summons. And it's really a fascinating process. I mean, it's the initial concept of having a jury trial was, during the Constitutional Convention when they were drafting the U.S. Constitution back in the late 1700s. And, the idea was that government should not decide if we're guilty or not of a crime. They can charge us and they can say, look, we think you violated this law that we have on the books. But it's our peers, people that live in our community, that will hear the arguments and the evidence that's presented by the government, and then they make the decision, the jury, is this person guilty or not? And so it's really a remarkable thing, that we have this system where it's like we restrict the power of government. Government has full power to charge you. That's their purview if they think that you did something wrong in violation of the law, but they can't decide that you're guilty or not. You have by right to have a jury make that determination. Near the end of the chapter, we talk about alternative dispute resolution. And so, for all the cases that go through the court system, most cases get settled out. That's true in civil cases. That's also true in criminal cases. So it's kind of like a mad race, in both civil and criminal cases. You're preparing for trial, you're getting through the discovery process, and, days or sometimes the day of the trial, the parties settle. And then the case is just over at that point, case dismissed. And so, you can't discount the need we have in our society for settlement to occur. If, I always give the example, if every criminal defendant, that was charged by prosecution, state and federal, if every criminal defendant said, I want my full right to a jury trial, and I'm not going to plead guilty, I'm not going to, enter into any kind of a plea arrangement or anything at all, our judicial system would come to a standstill. We don't have enough courtrooms, we don't have enough judges, we don't have enough attorneys to prosecute every single case. And so what we rely upon is that, if you're, let's say, a criminal defendant and you know that you committed the crime, if you're convicted, maybe your punishment is, 10 years in prison. But if you plead guilty, maybe the prosecution will say, well, look, we'll ask the judge for only 5 years, And so, we rely on criminal defendants to kind of realize that, okay, I could push this, and exercise every right that I possibly could have. But at the end of the day, I could be looking at a decade in prison as compared to only 5 years or less, maybe. So that's the whole point behind, we really do encourage parties to try and amicably resolve their dispute without going completely to the full extent of what the courtroom process offers. So in our alternative dispute resolution, mediation and arbitration are perhaps the two most common ways in which we try and encourage parties to resolve their dispute without having to fully go through the court system. And sometimes it works very well, either of these, sometimes not so well. I usually will ask students in class when it's in a face-to-face environment, how would you distinguish mediation from arbitration? And so, I don't know if you want to pause this right now, but, read each of the definitions and, maybe pause then this video and ask yourself, how are mediation and arbitration similar? How are they different? So that's like how you would distinguish them. So, fast forward, having the simulated conversation in a face-to-face class. Mediation and arbitration, they're both similar because you have two sides that are in dispute over something, and you're looking to a third party to try and help resolve that dispute. That's how they're similar. They're very different in how they actually get to that point of resolution, though. If we're talking about mediation, a mediator, all that they can do is encourage the parties to come to some kind of an agreement. They can't force a decision on them. I've been a party to both mediation and arbitration, in terms of representing clients. And mediation kind of goes like this. Usually there's a date that's set up and the parties will show up. It doesn't have to be, but it usually is at a law office. And so I've seen more common than not, the parties will all show up in the same room and they'll sit down. The mediator will be there, plus the sides that are in dispute. And the mediator will introduce him or herself, and they'll kind of lay out the objectives for the day, kind of like maybe a schedule. And then they'll have the parties go to different rooms. And the mediator will go from room to room, and they'll go to, side A first, and they'll be like, okay, this is, how I see your case. These are the strengths of your case. These are your weaknesses. Are you willing to concede anything? And then, he or she, the mediator, takes that information. They go to the other room where the other side is, and they do the same thing. And they say, strengths, weaknesses, are you willing to concede anything? And they'll say, well, the other side is willing to give here. Are you willing to give somewhere else? And this is it's like a tennis match. You're going back and forth as the mediator. And, at the end of the day, what you hope is that you have helped each side make enough concessions that, like a bridge builder, you have built an agreement. And you as the mediator, if you can get to that point, you don't let anybody go home until they sign paperwork evidencing the agreement. Once people go home, they start thinking, and then the deal falls through. But if they've already signed it, then they're kind of locked into that. But that's what the mediator does. At the end of the day, the parties may not be anywhere near in agreement, and so it's just over them. Probably the worst mediation that I had, it lasted like over 11 hours, and at the end of that 11th hour, we were nowhere closer than when we had started in the morning, and it was very, very frustrating. But sometimes mediation does work. You have to have two sides that are willing to cooperate and willing to make concessions in order to say that, okay, it's not the perfect resolution, but it's at least a resolution. Arbitration is different. Usually with arbitration, and when I think of arbitration, I think of binding arbitration. That's usually required by the parties to agree to. You can't be forced into binding arbitration against your will. And so with arbitration, both sides show up, and the arbitrator, that third party, he or she acts as a judge. And so their role is to hear the case. You can introduce evidence, you can introduce testimony, you can have witnesses, whatever you want to introduce for either side. And then at some point, the arbitrator deliberates and then renders a decision. And at that point, it's over. The value of arbitration, because businesses love to fold into their contracts, if there is a dispute, that it will be resolved through binding arbitration. If you agree to that, And, because that's something you could negotiate. But if you agree to that and there is a dispute, then you are locked into binding arbitration. You cannot go to court. Um, so, usually a binding arbitration decision even is immune from appeals courts unless you can demonstrate somehow that, maybe the arbitrator, took a bribe or there was gross negligence. There has to be something very, very unusual to kind of break open the decision by a binding arbitrator. But again, it's a fascinating kind of look into, these are different ways in which we can try and resolve disputes without having to go through the traditional courtroom process. To give you some kind of practical kind of applications for mediation and arbitration, in Florida, if you go through a marital dissolution, so getting divorced, judges are going to require both parties to go to mediation to try and hammer out the minor stuff, assuming that maybe they can't agree on certain things. Because really the last thing that a judge wants to do, because judges, they have so much work to do, for every case, they're just burdened. It's a never-ending sea of cases that they have to deal with. And, if there's a couple that's divorcing, they're going to be, unless they agree to everything, which you can do that, but that's unusual. A lot of times they fight over stuff, because it's raw, it's very emotional, it's a very painful process to go through a divorce. And, maybe each side is arguing over who gets, furniture or an heirloom or, all this stuff, who gets the family pet, I don't know. And judges don't want to hear that. They don't want to deal with that stuff. They'll deal with big stuff like, property distribution, like, alimony or child custody, if the parties can't agree. Judges will intercede and they'll try and, grapple with that. But, the easiest way to get a judge very angry is that, you can't decide who gets the dishware, the plates, the pots, the pans. Judges will be very upset then by that. So mediation sometimes can be required, even though you don't have to be successful in it, but you do have to show up for mediation, because then that's part of the process. Arbitration, I've seen this come up recently. I have an elderly mother, and sometimes I have to take her to doctor appointments. And I've seen here in Central Florida more and more physicians, as part of, if you're a new patient, part of the intake paperwork is that if you feel that that there's been a mistake performed by your physician or you've been injured in some way, that you are agreeing to have your case be decided through binding arbitration. And if you don't agree to that, you don't have to, then they're not going to take you on as a new patient. So again, that's an example where I think that's more of pressure being put on physicians from malpractice insurance carriers to try and stem the flood of cases that are being litigated when malpractice is alleged. But that's the reality of how this kind of comes into play when we talk about mediation versus arbitration. So I think this is the last slide. Let me check. Yeah, actually, this is the last slide. This is an example of famous arbitrators, even though you may not think of them like arbitrators. These are personalities on TV, and they give all the appearances of a traditional courtroom. But the reality is that each one of those persons, they are trained as an arbitrator, and you agree to waive going to a traditional courtroom so that you can appear on TV and have each of one of these judges, whoever you want to have them hear your case, they will decide and settle the dispute that you have. And again, at the end of the day, their decision stands. Out of these judges, I don't know the background on a lot of these judges, except for Judge Judy in the top center there. She actually was a judge in the state of New York. And somehow, I don't know how she landed the job of being a Judge Judy, on television. But I have seen interviews with her, and her annual salary as a real judge, in the state of New York, is what she gets paid per show. And so for her, she's very happy being, this kind of like this TV personality. She's very well compensated, for the services that she renders. But she's not acting as a real judge like she used to in New York State. She is an arbitrator, and it's for, part of it's for entertainment purposes, but she actually is resolving cases in the process. The other judges, I know Jerry Springer, obviously, he's notorious for a lot of different things. His show and other things that he's done on television. But the other judges, I don't know their personal backgrounds, but again, all of these persons collectively in these judge shows that they have, they're acting as arbitrators, even though they have the props and the appearances of it have it look like an actual courtroom. So it's a fun chapter, looking at the court structure that we have in the United States, that dual layered the state and the federal system, and as well as the alternatives to go into traditional courtrooms in the form of mediation and arbitration. So if you have any questions, like normal, please reach out to me anytime. But have a wonderful day, and I'm working on getting ready for the next chapter to produce a video for you all. But just stay safe, stay well, and I will see you all in future videos. Thank you.